know what the urgency here is, and this is simply an order short of time.
When would how much time do you need to oppose the motion?
If the court is inclined to grant the order short of time, I'd like to have at least 2 weeks.
Well, actually, time is of the essence here for the very reason just articulated. We actually, obviously, we're here because there has been the plaintiffs and the counsel have disseminated information from and the actual transcripts from several depositions. In this case, we have numerous depositions, regardless of any mediation. We have numerous depositions scheduled over the next several weeks, and we just got a transcript in yesterday from another deposition, and without an order, there's nothing preventing them from continuing the dissemination. Even yesterday afternoon, there was a text. Excuse me, there was I'm saying Twitter, but it was some social media post by one of, not the plaintiffs, but one of their supporters, specifically saying that we're going into court today before the judge issues anything. We've got to get this information out. And they gave some information out about another deposition just yesterday afternoon. So we don't know what else is coming. So this is actually, time is of the essence. So if you're not going to, if you're inclined to give them more time, at least we would request that a temporary order be issued preventing the dissemination pending the scheduled hearing.
I think that's too broad, Your Honor. We've already filed opposition papers in the summary judgment motion that contain some of these deposition transcripts for public record. And the DA has asked for some of these transcripts, and so this order would impact their investigation of this case, because one of these witnesses who came forward, this is a Me Too situation. When these cases were filed, suddenly all these women come out, and one of them who was deposed, which prompted this ex parte, Melanie Godinez, said he groped me several times.
Don't go in there.
Yes, sir. All of this is prompted an investigation by the district attorney's office, and the police want to interview her. So if this court issues an order without, it being briefed, then that's going to.
What about an order just limited to disseminating to the media?
Your Honor, I have no problem with some sort of temporary agreement that we will not disseminate to the media pending the order that has to be briefed on it. And our position is also, Ron, that Mr. Kasparian opened the door to all of this stuff. He disseminated this letter on all of these issues about sexual harassment and that sort of thing to 13,000 members of the union. And he went to the newspaper, I think, and gave them some sort of detailed letter about these allegations. So our position is, and this will be brief, our position is he opened the door to this. He cannot talk about this with the media. He cannot disseminate information about his position with all of these 13,000 union members, and then come in and have a gag order when some of these Me Too women come forward and testify about what he did to them.
These comments to the media and the letters were in response to the media request because of their dissemination of the transcripts. The media gets the transcripts, gets the information, they immediately call him to say, what's going on, your comment. It's a situation of, what do? Do I not say anything? So it's simply in response to what was out there, what was already disseminated. It's not a matter of Mr. Kasparian started this, or now tag you're it type of thing. It's not that. It's not happening that way. Everything that was done has been in response to what the plaintiffs and the counsel have given.
And I have no problem with agreeing to a status quo. We won't disseminate to the media until this matter is heard. That should alleviate his concerns.
Well, it doesn't. Our motion is not just limited to the media. We're not trying. We can't, obviously. We're not asking them not to talk. They have every right to say what they want. But our motion is to prevent the dissemination of the information derived from the depositions and the distribution of transcripts. So it's not just to the media. It's not just. It could be other people doing it too. So at their instruction. So we want to make sure that they're not posting on social media themselves the information, just like what I indicated to you happened yesterday afternoon.
Your Honor, I have no control over all these other witnesses who do what they want to do on Facebook. They're not my clients. I can instruct my clients to not communicate to the media or post anything on Facebook until this matter is heard. But I have no control over other witnesses who decide they want to tell the media or whatever about what they view of the facts of this case. But our position is, let's have a status quo. I will agree not to disseminate any of these transcripts, because that's what this is about, to the media. Until this matter is heard.
But the only way other people, first of all, like the person yesterday, knows about it is because somebody, the plaintiffs or their counsel, told them, okay? They're the only people who have access to the transcripts and to the deposition information. So the order we're seeking, and even a temporary order, should prohibit the plaintiffs themselves and counsel from disclosing anything about the information from or the transcripts.
What they're asked by, like you mentioned, the DA.
Well, we're not, obviously it would seem, well, I would say that should be prohibited too, given the nature and the personal nature of what we're talking about. The district attorney obviously is part of the court system, so they could, potentially subpoena documents and we could respond in that kind of a setting. But, I don't think they should be talking to the district attorney.
Okay.
In these three cases, by the way, I don't know anything about the district attorney. Mr. Corrales is telling us this, and what he said to you, Your Honor, is in a new case that was filed that's not in front of this court, that's who the DA is talking to. There's no indication. I've heard nothing from Mr. Corrales that there's discussion with any of the plaintiffs. But again, we're talking about, what we're talking about here is important personal sensitive information that simply should not be disclosed.
Your Honor, he's asking for a gag order without without me knowing exactly what he's talking about, and I can't disclose the details of that because of what the court has just ordered. So yes, the DA is interested.
Plaintiffs and their counsel are not to disseminate the content of any discovery or to discuss the content of any of the discovery with the media or disseminate the content of any discovery to anyone except to law enforcement or any branch of law enforcement in response to a specific request. So I don't, and by saying that, I am not saying that there should be any such request from law enforcement. You just brought that up.
Yes, sir.
Or there's even, I'm not saying there's probable cause for that to be happening. I don't have any information or enough information to make any decision, and I'm not being asked to make any decision about that, and I'm not. All I'm trying to do is to not interfere with any investigation, if assuming there is one, and I don't know that, but at the same time to maintain the status quo in terms of dissemination of information.
Yes, sure. And the court is basically ordering this in terms of the status quo pending.
Correct. This is a temporary order pending the hearing on the motion.
Yes.
Can your temporary order, though, the way you read, you just outlined it was with the media. Our concern is that it would not stop them from talking to their friends and their supporters.
I said disseminate. I did say disseminating any information from the discovery.
Okay, not just limited to the media. Okay, thank you.
And beyond, those that need to know. Just like it's sort of like a protective order.
Yes, sir.
Counsel and clients, or if they're experts.
Yes, sir.
Of course.
And just so the court knows, this does not, I'm asking the court, that this does not preclude the media from looking and finding things that have been filed with the court.
I'm not enjoining the media, only
Yes, sir.
you, Mr. Corrales, and Mr. Gillian, and your clients.
Yes, sir. So whatever is public record or has been filed, that's not what the court.
That's not part of the request, and
That's right. That's fine.
That is correct.
Okay.
Thank you, Your Honor.
Thank you.
okay.